I want to go ahead and begin my talk about troublesome tenants and the kinds of things that you can do either for your own property that you manage on behalf of landlords or your own, as well as how to serve in an advisory capacity to people who do lease residential real estate to others. So I want to talk about first the issue of eviction. A lot of what we do is we deal with problems after the fact. And so I will talk about eviction and what that process looks like, but I also want to talk about the kinds of things that lead to eviction and ultimately the kinds of things that prevent it. Right from the start, let's talk about what it means to evict someone in the state of Texas. In Texas, the very first thing that has to happen is that a notice must be sent to a tenant. And that notice is referred to as a notice to vacate. And depending on some factors, generally speaking, the notice to vacate is a 3-day notice that is mailed to the tenant regarding some breach of the lease. What we recommend always to landlords is whenever you have a tenant who you're seeking to evict, that you should send over notice to vacate in a very specific way. The property code allows multiple different ways to send out that notice to vacate, but we like suggesting a very specific way. And so what we recommend is that we send 2 copies of that notice, and this is the way all of our notices are sent. 2 copies of that notice. And so the first notice is that regular, put a stamp on it, drop it in the mailbox kind of notice. The second, though, is through certified mail. So why do both? Well, we want to be able to prove to the court that we complied with our end to notify a tenant of the notice to vacate and warn them that if because of their breach, if they now after receiving notice have not vacated the property, they're subject to an eviction. So you may be asking yourself, well, why would I need anything other than my oral testimony that I went and I left a copy of the notice with the tenant? Well, because sometimes tenants testify and contradict what you say. You may say, I handed it to tenant X, and tenant X says, I've never seen you. I have no idea. That notice was never delivered to me. But if you can present evidence of mailing, then it's going to be much easier to establish for the court that you, in fact, complied with your end and delivered notice. And so now back to the reason why we send both regular and certified. Well, regular mail cannot be rejected. And you may be asking yourself, well, what if someone marks it return to sender? Well, in doing so, that person has actually received it. And by marking it return to sender, if it comes back to you with their handwriting on it, it was received. Whether it's read or not is irrelevant. The fact is, if it was delivered to them, you've complied. Now, what if they don't do that? It gets delivered, and you send the notice via certified mail, return receipt requested. Well, what should happen is the letter should be delivered both together since they're mailed together. And on that trip, the letter carrier should have the tenant sign off on the green card, and that green card gets sent back to you, the sender. And that proves that this notice was delivered. However, what we know is that in many, many cases, about 80% of the time, this never gets delivered because either the tenant refuses to take it or just isn't home. And so this inevitably ends up coming back to us. But what's important is the ability to track the letter. This tracking number allows us to see when the notice was first attempted delivered. And what we know is if we mail 2 letters at the same time, and this was attempted delivered, then this was definitely delivered. They're mailed at the same time. They couldn't drop this one off because no one was there to take it, but they can always drop off regular mail. So we can establish the date on which the notice was delivered. We call that day 0. And if you're given a 3-day notice, day 0 is the date of delivery. Then 3 full days must pass, And then on day 4 or after, an eviction petition may be filed. So first things first, you got to send that notice to vacate. Next, you're going to want to file, and the filing happens in the precinct in which the rental property is located. It's not the precinct that's closest to you, the landlord, or the precinct that's closest to you, the property manager, or the precinct that you like the most. It's the precinct in which the rental property in question is located. You file in that precinct because that precinct has jurisdiction over all of the rental property within those boundaries. If you're unsure which precinct applies to you, simply call any court and ask for some guidance. Generally speaking, the clerks will be able to guide you to the correct precinct where you can file your eviction. There are also some online databases that'll point you into the right direction. Now, the last thing is trial itself. Once you have filed, once the matter is set for trial, what is it that you need to prove in order to successfully evict a troublesome tenant? Well, basically, it boils down to 4 things that you as the landlord or as the plaintiff in an eviction matter have to prove. The first is the agreement. And that's generally pretty easy because most of us operate with a written lease. That written lease is your agreement, but Texas actually allows oral agreements as well. Now, if you have an oral agreement for a tenant, you basically have only agreed on 2 things: the address of the property and the amount of rent. That's basically it. There are no other terms that are going to easily be proven when your agreement is 100% oral. I dissuade landlords from maintaining purely oral agreements. You should always reduce your agreement into a written lease, again, because it's the easiest to prove what your actual terms of agreement were. You establish your first proof that you had an agreement, that you had an agreement for a certain amount of rent owed by the first of the month, and that rent has now gone unpaid. Or you had a prohibition in your lease to damage on the property, or unauthorized pets, or unauthorized occupants, or some other terms that simply were not held up by the tenant. And that leads us to your second proof, which is breach. You can't just prove that you had an agreement. You must move on and prove that the tenant violated that agreement. And the most common one is non-payment of rent. We refer to that as the gold standard in eviction. If a tenant simply has not paid rent, there are generally no defenses to non-payment. However, if your tenant has paid rent, but they violated the lease in a number of other ways, then you are still entitled potentially to an eviction if you can establish that breach. So the first is an agreement, the second is breach, the third is that notice. If you've mailed a notice to vacate by regular and certified mail, as we suggest, you're going to want to keep a copy of whatever was included in that envelope so that along with your proof of mailing, which typically is a receipt that you get from the post office, along with the proof of mailing, you can establish what you stated to your tenant about the notice for them to leave. Typically, a notice to vacate should be an unconditional demand for possession. And what you're saying essentially in that notice is you're in violation, you must now leave. If you fail to leave by date X, or basically if you fail to leave after 3 days from having received this notice, then I can proceed against you in a court and sue you for eviction. So you've proven up the fact of an agreement, you've proven up the fact of a breach, you've proven up the fact that you delivered notice properly. Your final proof is, what are you asking the court for? What are your damages? Inevitably, in an eviction, the big one is possession. Possession of the property is generally the most important thing you're going to claim. But you might also claim unpaid rent, attorney's fees, court costs, and interest. What you cannot claim in an eviction, however, are things like late fees, pet charges, unpaid deposits, HOA fines. Anything other than rent, attorney fees, or court costs simply cannot be awarded in an eviction. And you may ask yourself, well, how would I recover those things? Well, you might be able to recover those from the security deposit. Otherwise, you probably have to collect them from a separate civil case. So the eviction is a very narrowly tailored civil claim that you can use in order to recover possession, unpaid rent, attorney fees, court costs, and interest. But that's it. Any other fees would have to be dealt with in a separate manner. Now, once you won your eviction, the bad news is that every single eviction in a Texas justice court can be appealed. The good news is that 80% of them never are. The majority of evictions start and end in the justice court. For those that do go on to an appeal, those will be heard at the county court level. In other words, it doesn't matter what you've already proven to the justice court. That record is closed and no longer exists. So in order to prevail, once a tenant has appealed, you'll have to follow the case into the county court, present your 4 elements of proof all over again, and then secure a new judgment. So let's say you finally do have a final judgment, whether you secured that in the justice court or in the county court on appeal, and the tenant still will not leave. The fact is, the judgment alone is not enough. If that tenant will not voluntarily vacate the property, you have to take another step. And that step is referred to as a writ of possession. This is an order that's signed by the judge that goes out to the constables in the county that says essentially the following: post this notice and give the tenant 24 hours of warning time, that after 24 hours, you may go in and remove the people and remove the property from the premises. The judge signs this order, sends it to the constables. A constable will go to the property and tape the notice on the front door. If the tenant is still there when the constable returns, then yes, the constables can remove the people. Typically, the landlord and a moving crew will remove the property, and typically that property is placed on the curbside for heavy trash pickup. Now, I'll tell you that this is not a common occurrence, but it does happen where all steps have to be taken because a tenant is so belligerent and will not listen to reason and fails to adhere to any of the warnings of the county that they lose their personal property in a writ of possession situation. Again, not super common, but it might be that you do have to purchase it as a final motivation to that tenant to get them to leave. So that's an eviction carried out from start to finish, kind of in a nutshell. There are 1,000 things that we didn't cover, but those are the eviction basics. So we're going to back up a little bit. Let's talk about when you're giving notice at all. Because there's 3 notices that should be handed out during a tenancy that sometimes landlords get wrong or property managers fail to see the importance of. So we're going to talk about these 3 notices and what I would recommend in terms of delivery of these notices. So the notice that we already discussed was a notice to vacate. This is the notice that says that this lease is over, you are in default, and you must now leave. When should you deliver a notice to vacate? Well, when it comes to non-rent violations, I preach a 3 strikes and you're out message to landlords. If they violated the lease in some substantial way, even if they're paying rent, but if they violated the lease 3 times and you have notified them, then it might be appropriate to issue a notice to vacate because they simply won't follow the lease to its fullest extent. Now, make sure these are substantial violations and not slight ones. A slight violation might be, for example, the tenant waited an extra day before they watered the grass, or they waited an extra day before they brought in the trash can. But ultimately, they did water the grass and they did bring in the trash can. You don't want to be so picky that you create a situation where a judge is simply going to turn you away and say, this just isn't enough for you to demand possession. I agree it violates the lease, but go work things out between yourselves. Now, substantial violations should be met with notices of default. And a notice of default puts the tenant on notice that what they're doing is a violation. It's not a notice to vacate. It doesn't say get out. It says instead, I recognize that you have violated the lease, and I'm asking you to cure that violation within a reasonable amount of time. Let me give you an example. You might have a situation where someone acquires a pet after a lease is signed. This is a common violation. The lease itself prohibits pets or prohibits pets without prior written authorization, but they brought a pet in anyway. What do? Well, depending on the terms of your lease, generally speaking, you can issue a notice to vacate and say, you've got 3 to 5 days to get rid of this pet. It violates our lease. You must get rid of it. You might also say you've got 3 to 5 days to sign this pet addendum, agree to pay additional deposit, and agree to certain requirements for this pet that have to do with maybe the size or the breed or the number of animals that are allowed, those kinds of things. So if there's a breach, you should meet that breach with a notice, give an opportunity for the tenant to cure, and if they cure to your satisfaction, no more problem. However, if there is breach after breach after breach, let's say, for example, instead of one small dog, somebody brings in 4 large dogs, which you would never have allowed in the first place. And you give a notice that says, please remove these dogs in 3 to 5 days. And on day 6, you show up, nothing. The dogs are still there. So you issue another notice. Please remove these dogs within 3 to 5 days. Again, you show up 6 days later, same dogs, they've done nothing. You issue a third notice. And your notice should be very clear. You must remove these animals. They violate your lease. That third one probably should say something, and really each of them could say something to the following effect. Continued violation of this lease may result in lease termination and delivery of a notice to vacate. And the importance of this is, if you've done this 3 times over a short period of time and given a reasonable amount of time for the tenant to cure, now you have a much more convincing argument in front of a judge that you are entitled to possession because you've given this tenant an ample opportunity to cure their default. They simply haven't done it. The final notice is a notice of lease termination, which sometimes is confused for a notice to vacate. I want to explain the difference between lease termination and a notice to vacate. A lease termination does not ever necessitate breach. You might have a lease with an automatic renewal clause, and you may have a lease that has automatically renewed or has been renewed by written agreement for multiple years. But now you're seeking to use the property in a different way. Maybe you mean to market the property to sell it, or you're going to do a major rehab and you want to end the current tenancy. And so you know that the lease will end, for example, on September 30th, 2024. And so you send out notice timely, right? If you, for example, must give 30 days of prior notice, then you send it out with at least 30 days before that date to your tenant saying, please vacate by that date. On this date, the lease will end. Well, let's say you've sent the notice. You can prove that you sent the notice because you sent that notice through regular and certified mail. And then you get to October 1st, and wouldn't you know, the tenant is still there. Can you at that point go to the courthouse and file an eviction? And the technical answer is no. Because prior to that date, the tenant had not violated the lease. Assuming that rent for the month of September was actually paid, there was no violation on the 30th of September. The violation didn't occur until October 1st, when they remained beyond the date of termination. This is referred to as holdover. Now, because of holdover, you can issue a notice to vacate. And now you say you have 3 days to leave before I sue you for eviction. You are not allowed to be here beyond the date of termination, which I sent timely on such and such date. If they stay beyond that date, then you may after a subsequent notice to vacate, file that eviction. And unfortunately, too many times, landlords are unfamiliar with the necessity to terminate a lease in writing. But if your lease has an automatic renewal clause, you are required to do it that way. The tenant may do it or you may do it, but it must be in writing, and you must be able to demonstrate to the court that you in fact terminated the lease. If you mean to, you must do it in writing, and you must do it with the requisite number of days, the minimum being 30. Your lease may require 45 or 60. Whatever the case is, it cannot be fewer than 30 days, but it must be in writing, and you must be able to prove that you delivered it to your tenant. The plan that you have, whether it's to deliver a notice of termination or a notice of non-renewal or a notice of default or a notice to vacate, should be, number one, in your mind before you ever need it, and number two, should be practiced consistently for all of your tenants. You shouldn't have a different set of rules for this tenant because they're so sweet and nice, and this tenant because they're mean and nasty, and that tenant because they gave you the stink eye once. You should have a policy that is uniform for all of your tenants so that you're not accused of treating certain tenants differently than others. The policy I recommend is a 1-3-7 policy. Very simple. 1, if you are a forgiving person, and you may be, I do not recommend forgiveness more than one time in a 12-month period. Maybe they're going to be late with the rent, or maybe they violated a term of the lease unknowingly. And you forgive them, not a problem. But once you start forgiving them 2 and 3 and 4 times, now you're just condoning bad behavior. If you're going to forgive at all, and you're not required to, but if you're going to do it, don't do it more than once within every 12-month period. It's just a bad policy to continually let your tenant breach their lease. 3 strikes and they're out. Even if they're paying rent, if they have 3 substantial lease violations and they haven't cured them, you should probably issue a notice to vacate. And 7, if you've gotten to day 7 and have not collected 100% of the rent, you are recommended to issue a notice to vacate, because statistically speaking, if by day 7, 100% of the rent is not paid for a given month, the chances that rent will be late the following month or not paid at all are extremely high. The majority of good rent-paying tenants paid well before the 7th day. The majority of bad tenants paid on the 7th or after. These are warnings to you that this tenant is just not a good fit and that you should issue a notice to vacate and ultimately, as needed, proceed with an eviction. Okay, that's dealing with problems. How do you prevent problems? Well, the first way to prevent a problem is to talk to your tenant before you ever hand over keys to your property. And not enough landlords do this. Not enough landlords lay out, for example, I have a 1-3-7 policy with lease violations. And I wouldn't mention the 1. I wouldn't say you get a freebie. But I would mention the 3 strikes and you're out, or the 7-day for payment of 100% of the rent. So if you can articulate to your tenants, for example, if we've got multiple issues where I've cited you with written notice of default that just isn't cured, then it probably means we don't work well together and I'll have to issue a notice to vacate. I'm certain that's not going to be the issue, but I do like to mention this to all of my tenants before we begin the lease. The 7 is also important. If by the 7th day of the month I have not received 100% of the rent, I will be issuing a notice to vacate. That is our policy in terms of management, and it's the best way to make sure that rent is always timely paid. Notice that I didn't say you wouldn't have to pay late fees, because late fees can begin on the 4th. You will pay late fees, and if I don't get 100% of what's owed by the 7th, unfortunately, at that point, I will issue a notice to vacate. Again, I'm certain that won't be an issue, new tenant, but I just wanted to be upfront about what our policy is with regard to payment of rent and non-rent lease violations that are not cured. The next thing is just to have a good lease. If you don't know if you have a good lease, then you got to ask. I always recommend that you ask somebody who's done what you're doing many more times and for many more years than you have. Those of you in this group are probably well suited to ask a lot of questions. In particular, what about my lease? Is it any good? Because there are a lot of leases out there. Some of them are more popular than others, and some are better than others. Here's a rule of thumb. If your residential lease is 1 or 2 or 3 pages long, it's probably just not enough. There's probably not enough substance in there to protect you as a landlord. If you need to get your lease reviewed by a professional, find somebody who deals with this and have them look over your lease to see if there's something better that you can offer to tenants to make sure you are well protected when the time comes for it. And then finally, you always want to engage in excellent screening. Before you ever present a lease to someone, you want to screen for them and make sure that, like the way that you navigate your management, imposing the same rules on every single tenant, you should have the same criteria for every prospective tenant. In fact, you should probably have that listed out in writing, preferably on something that a tenant or a prospective tenant can sign and agree to be subject to. For example, you may have a certain standard when it comes to the number of years of employment with the same employer. You may have certain standards that come from, I don't know, criminal history or salary or credit score. Whatever your criteria are, you should know them, but also be able to produce them in writing to all prospective tenants and let them know, unless you meet these minimum standards for each of these items, we will not consider you as a viable potential tenant. And by letting them know up front, you're going to lose all of the looky-loos who don't qualify even slightly for your property and only focus on the people who are the most qualified. But great screening doesn't just come from having a list of good criteria. It also comes from your own diligence. I've had a number of landlords who take on tenants who on paper look excellent, but who never took the steps to confirm what the paper showed. One simple one is to call that employer and confirm that the tenant even works there, that the employer even exists. I get landlords who come into me and say, I had no idea this was a fake job. Well, a simple Google search could have told you that. And I demonstrate that for them in my office by just looking up the details that are in the application. You could determine that there was fraud in the written application. That's not somebody you ever want to lease to. So by preventing more of these problems with excellent screening, a great lease, and being upfront with your tenant, having great communication, you're less likely to implement your 137 policy. But when you must, you should do it uniformly for all of your tenants and be diligent with the notices that you give and make sure that you send them in a way that the court will recognize. So that finally, if ever you do have to file for an eviction, you are set. Not only have you prepared your tenant for this potential eventuality, but you have prepared your own records for an excellent presentation in front of a judge so that you can recover your property faster and make even more money than you expected because your losses have now been reduced to virtually zero. Having a bad tenant is not the end of the game. It's a bump, but if you can prepare for it, it may actually not be as big a problem as you might predict. You must be proactive and you must be ready when the time comes to deal with a problem tenant every single time in a similar way across the board. Now, for those of you who are interested in a do-it-yourself path to eviction. Maybe you're in a position where you need to institute an eviction, but you're not quite ready to hire an attorney to assist you, or you need some assistance, but you can pretty much figure it out on your own as long as you had a bit of guidance. Well, I'm happy to share with you an eviction course for landlords in the state of Texas who are interested in learning more about the eviction process. I have an eviction course that I've created that takes you from start to finish, all the way from notice to judgment, even through the appeal process. If you go to my website, www.attorneyeg.com/EV, you can take a look at what we've got there and see a description of this course. It's 6 modules that takes you from notice. It has forms that we walk you through. I even instruct you on how to fill out notices like a notice of termination, a notice of non-renewal, a notice of default, a notice to vacate, all of which line up perfectly with the state of Texas and the requirements for a Texas landlord to evict a tenant in a Texas court. I then guide you through the process of filing, trial, and even appeal. If this is something that you find would be helpful for you to know while you're filing your first, or maybe you've filed 1 or 2 evictions in the past and just want to make sure you're doing everything right because you've got a challenging one in front of you, I strongly encourage you to go to www.attorneyeg.com/EV for our eviction course. Any questions you have, send me a text or an email, and I'll be happy to answer questions about that eviction course for you. That's attorneyeg.com/EV for your eviction course.
Can you file the writ of possession at the same time you file the eviction?
No. A writ of possession will issue once you've secured a judgment. So, and that writ of possession is subject to a couple of additional rules. Not only do you have to have a judgment, but typically the court will give the tenant about 5 days to file an appeal. The rule says 5 days. Some courts give it a 6th day, but generally they're going to be given some opportunity to file an appeal. Their failure to file an appeal subjects them to that writ of possession.
What happens if the tenant files for bankruptcy in the process?
That will likely cause a delay. It's not an absolute prohibition to the eviction, but it will cause a delay. Automatically, all procedure is stayed until the bankruptcy court allows the eviction to proceed. What typically happens is the landlord has to enter into the bankruptcy and then request what's called a lift of the stay from the bankruptcy court. This can be done in as little as a month or 2. But if nothing's done, it could go on for several months. So our recommendation at these times is for the landlord in a situation where a tenant is filed for bankruptcy to hire a bankruptcy attorney simply for the purposes of entering into the case to request a lift of the stay. Because this is not like home ownership or the ownership of a vehicle or credit card debt. The tenant doesn't have the same interests in a lease as they would in a home that they owned. So they get less protection, but you do have to follow these procedural steps in the bankruptcy court.
Actually, we can actually do it because we have to pay extra fee for that bond in the beginning.
Yeah, so the problem with that, and yes, you're right, the fee is paid up front for that writ of possession bond. The problem with it is once the tenant shows up, you're right that if there is a default and nothing is done, then yes, you potentially could save some time on that writ of possession. But if the tenant is going to fight, they're going to fight either way. They're going to show up, they're going to appeal, they're going to file an answer, and that upfront payment doesn't really help you much. Typically, it might buy you some time, but again, a tenant who was going to leave early was going to leave early anyway. A tenant who was going to stay and fight is going to stay and fight. And so I've rarely seen where the payment of that writ of possession bond has really helped the case at all. Either, again, A, the tenant was on their way out anyway, or B, the tenant's going to show up and they still have a right to an appeal. There's nothing necessarily wrong about it, except for the fact that you as the plaintiff are paying additional money for something that may or may not actually get the property back anytime sooner. So because of the fact of an appeal, we generally don't advocate operating in this way because either A, the tenant's going to move out prior to trial anyway, or the tenant intends to appeal. And so the 5 days in the long run that you might save doesn't end up saving that much time because the writ still has to go through its own process. And we tend to estimate that as 2 to 3 weeks anyway. And so, yes, you might save a few days, but again, in my experience, it has not been that fruitful. So it's not something that I generally recommend across the board.
Have to pay more. I have never done this, but I always thought like, shall I do it?
Correct. And that's even less likely unless they show up with their own attorney, right? Or if they have a legal aid attorney. And depending on your county, some counties do have attorneys that operate from aid organizations that go and offer free attorney representation for indigent tenants. And if you're in that situation and you did pay a bond and they did cite a small procedural error, you're right, it could result in not just a loss of time or money, but an impediment to you in the long run getting the relief that you're seeking. So yeah, less of an advantage than it seems like in theory.
Certified. Or was it a letter mail? So what's your comment on that email?
So it depends on what the notice is. It also depends on whether or not email is listed in your lease as a method of providing notice to the other party. What we find time and time again on leases is that the notice provision is blank or it is deficient. It might have a bunch of information for the landlord, but it has zero information for the tenant. We always strongly recommend that your lease have multiple ways of you sending notice to your tenant. Personal email, work email, cell phone, the ability to text. If they have a work fax machine, maybe you have a tenant portal. As many possible outlets as you can have for communicating with your tenant, we strongly recommend. And so if you have it in there, then it's a maybe. The notice to vacate, however, is not validly delivered through email. The Texas Property Code says that for a notice to vacate specifically, you can send it through the US mail, regular and certified is what we recommend. You can put it in their hand. You can attach it to the inside of the main entry door. In very rare occasions, you can put it on the outside of the door, but it's not something that we recommend because there are so many stipulations that it's very, very easy to get that wrong. The final way is to put it in the hand of an occupant of the property, 16 years of age or older, which we also do not recommend because that also is fraught with potential pitfalls. So the best way to do it, we recommend, is by regular and certified mail. However, a notice of default can be delivered by email, and a notice of lease termination can be delivered by email if the email is listed in the lease as a valid method of delivery for notice. Last thing, while you can be turned away at the court for lack of notice, no one is ever turned away for extra notice. So if you want to send it by regular and certified mail and post it on the door and send it by email and fax and WhatsApp and post it wherever else they give you access, do that. But make sure that you always have a method that is always acceptable for the court. Our recommendation is regular and certified mail, just like this.
Or it goes by the property code. I don't know if in the property code it is written there or not.
It's valid for every notice except the notice to vacate.
Okay, you said that.
Right. So vacate notice is the only one that prohibits email communication.
Thank you.
Currently. I imagine eventually it'll change, but for now, it's not allowed. And that's to say it's not allowed exclusively. If you do it in conjunction with a valid method, not a problem. Can any individual do that?
The property manager.
The property manager. So in Texas, on the justice court level, yes, a property manager can file on behalf of an LLC, a corporation, a limited partnership. However, once it gets appealed, there are certain limitations for the kinds of evictions. So typically, on appeal, the property manager probably wants to take with them an officer or an owner of the company so that they testify. Because they can represent their own company in an eviction on appeal. In the justice court, a non-attorney can represent even a corporation in an eviction matter.
New leases, like address, phone number, that kind of stuff.
You do not have to put it on the lease, but if a tenant requests it, you are required to give them that information. Your failure to give them that information allows them to unilaterally terminate the lease and walk away from the lease without harm. So state law now requires that you must disclose that information. So what we recommend, I'm sorry?
Like what exact information, even their phone number?
A contact information, a mailing address. So the name of the owner and and a way to contact them, which could be a post office box, which is what we recommend.
Yeah, just mailbox is fine for that then.
Yes,
Sorry, entity or a company.
I see. So a company as in, well, I guess it depends on your lease. If it's a commercial lease, that's common. If it's a residential lease, I mean, an LLC or a corporation or a limited partnership doesn't have a residence. And so it's kind of a conflicting term for an LLC to reside on residential property. So if what the tenant is trying to do is shield themselves from personal liability, I would see that as a red flag. And certainly you could do it, but I wouldn't do it without additionally having them sign a personal guarantee of some sort. And just to be frank, I don't think it's a good idea at all to lease a residential lease to an entity.
Corporation, it could be a short-term rental or a temporary accommodation kind of company or someone.
I see. So you're talking about a situation where you as a landlord lease to a company and they're going to sublease to others.
Correct.
Yes.
Yes.
That's an extremely dangerous lease because you have no idea who your tenant is allowing onto your property or how they are using your property. Additionally, how are you going to insure for that? Your insurance may not cover that specific kind of operation. You'll want to make sure that the policy that you have in place isn't just a straight landlord-tenant policy. You would need a business commercial policy for that type of rental. And so you may think twice based on the liability that you may have from that kind of operation. And really, if you've got a corporate tenant and then you've got an unknown occupant, you've got all sorts of risk. So that along with your own insurance, you're going to want that corporate tenant properly insured. And then you're going to want to make sure that you can confirm that they maintain that insurance. It's not an impossible situation, but it is a risky one. And if you are not a sophisticated commercial landlord, this may not be something that I would advocate.
Try to rent a place that had like a 6-car garage. What does that look like in your eyes? That guarantor?
So let's say you're the landlord and you've got, again, and it's very similar, you're leasing residential property for a business use. Am I hearing that right?
Yes.
Okay, so you're leasing residential property for a business use. Number one, you want to make sure that you're not in a homeowners association that restricts that or prevents you from doing that legally. But let's say that you're in an area where it's perfectly allowed. So you can have commercial vehicles on residential property. Okay. But you want to be protected in the potential event of a breach. And so you might have the principal owner, if it's just one, or if there's a partnership, maybe both, sign personal guarantees in the event of some kind of breach, either for non-payment or maybe a destruction of property or some other matter that comes up. If you're using the Texas Realtors lease, there are guarantees that you may have access to if you have access to that lease. If you're using some other lease that doesn't offer that, you may want to talk to an attorney about securing a personal guarantee for that particular lease for that specific use. But before you ever get there, make sure you even have the authority to lease property in that way. You may have zoning issues with the municipality where the property is located. You may have deed restrictions based on the covenants of your property that are in place at the time.
Option to not take payment in the event that they are in default and you serve them notice and you've already started the eviction process.
Let's assume we've gotten to day 7, like I recommend, and you've issued a notice to vacate. And you tell the tenant, you know what, don't worry about it. You don't owe rent, just leave. And at first it appears that they do that. In fact, they box everything up, but then they have a change of heart and they decide, no, I think I'm going to go ahead and stay. And then you file your eviction and you go in front of the judge and you tell the judge, Your Honor, they didn't pay rent for the month of X. And they say, Your Honor, I agree. However, they waived the rent. Here's the text where they said I didn't have to pay. Now, it may be that what you meant was, if you leave, we won't come after you for that money. But an inartfully stated proposition could be used as evidence against you. I warn landlords all the time, never, ever, 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 ever waive rent. Sometimes landlords think that by waiving rent, it speeds up the process. It can actually make it much worse. Sometimes at trial, because the issues are convoluted or complicated, the landlord will just say, you know what, Your Honor, I don't want any rent. I just want possession. And so the order is possession only, no rent, yada, yada. Well, you've just given that tenant the opportunity to appeal for absolutely free because rent is not at issue. Whereas if you had said, Your Honor, they owe a month and a half of rent, I want a full judgment for everything that's available, and they establish rent as X. If they file an appeal, they either have to pay a cash bond or rent regularly into the court's registry during the course of that appeal. A free appeal doesn't motivate them in any way to move. An appeal that costs them money is a motivator for them to move, especially if they don't have the money. But if they do have the money, like in your case, where they change their mind, well, guess what? You still have the same cause of action against them for non-payment initially. And they may take that money and pay it into the court's registry and stay during the course of that appeal. And guess what? Even if they appeal, the landlord both gets a judgment for possession and they get rent that was paid along the way so that their losses have been minimized. But always, 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 we suggest by day 7, you haven't gotten it, send a demand to vacate and never, ever let the reins go. Don't ever do them the favor of making it easy for them to continue to breach. It should be difficult. It should be cost prohibitive for them to continue to breach the lease.
They've not been late just 1 month, but they've been late 2 months. You can ask for both months' rent at the courtroom, correct? All back rent.
I've seen it where property managers have gone 10 months and not collected a nickel of rent. They have no idea. They're pulling their hair out. They tell me, Ernie, I have no idea what I'm doing or how to fix it, but we finally need to get rid of this tenant. They keep promising they're going to pay. Their ship's almost coming in every single time, and something happens and the money doesn't come. And I say, well, okay, so you've waited 10 months and the rent is $2,000 a month. So now you're $20,000 in the hole. Here's the problem with this. Right now, it's August 22nd. If I file that eviction today, let's assume we've already sent a notice to vacate. There's no way we're going to get to trial before the end of this month, which means on September 1st, they're going to owe more than $20,000 in unpaid rent. Do you know how much money I can get awarded to your landlord at that point, it's zero. Because now the jurisdictional limit of the court has been exceeded. Yeah, I can get an order for possession, but if I am honestly presenting the case to the court and there's more than $20,000 of unpaid rent, I can't even get a judgment. So in no way does it help anybody to wait beyond 7 days. And so, yes, you can ultimately, if you're within the jurisdictional limit of the court, you can recover 1, 2, 3, 4, 10 months potentially. But at a certain point, there's going to be a huge diminish in those returns, and it could get to zero. Along with the simple fact that if a tenant has trouble paying $2,000, they're never going to pay $20,000. And so you have to presume that the biggest loss isn't the rent, it's always the property. That is the more valuable asset, and you got to get a bad tenant off of good property.
So 2 questions. What should we do about the belongings? And second, what should we do after this month?
TAA lease?
Texas Apartment Association.
Texas Apartment Association. Very good. Okay, so that lease should have an abandonment clause in it. And if the abandonment clause talks about what procedures a landlord can take in order to declare personal property abandoned, then you can follow those steps and declare everything abandoned. One of those options might even be to just discard everything. But typically, abandonment doesn't occur until there's been a breach. So my first question to you, the fact that a tenant has been arrested may or may not be a breach unless they conducted the illegal activity on the property, and you can prove that. But assuming they got arrested off-site, they're in jail, they're not coming back, but they've paid rent or somebody's paid rent on their behalf through the month of August, they're probably not in breach yet. But come September 1st, or whenever the rent is due, once rent is due and unpaid and there's a breach, go to the portion of the TAA lease that talks about abandoned property and follow those procedures. It might require you to send written notice to that tenant, which might be as simple as going inside, opening the door, putting it on the inside of the main entry door and leaving it there. And then once the requisite amount of time has passed, if they have not paid the rent and or cleared everything out, once you've declared the abandonment, then you should be able to simply discard all of their property in accordance with the lease terms. So whatever your lease says regarding abandonment, that's what you could do. Could you also file for eviction? Yes, but that's a longer process usually, a 30 to 45-day process. So assuming non-payment in September, you could issue a notice to vacate. Of course, their stuff's going to be there, so they still haven't technically vacated. So then you file, you get a judgment, you get a writ, the constables come over, then you empty out the unit. Yeah, but that's probably going to take 45 days or more. Whereas if your lease allows you an abandonment provision, then you might be able to do it much, much sooner. Again, you're probably going to need breach for non-payment, and then you deliver the notice and then see what happens. It's possible they have family members who are given access to the unit who come in, clear it out, and it's a non-problem. But if you have an abandonment provision in your lease and they are in breach, you might be able to get in there and clear it out much sooner by following that procedure. What I always recommend to landlords is that they send notice everywhere. Don't just send the one notice. If you have an email and a phone and a text and a fax and a business email and a neighbor and a mom and a grandma, send notice to everybody and say, if the lease says I can clear this out in 48 hours, I will do that. Please come and clear these things out, or I will exercise this right under the lease. By proving that you gave notice in this way to everybody identified in the lease, you're going to be better off, and you're going to likely prevent some frivolous claim that you violated the lease. You got to prove that you followed it, though.
No way to contact them. Can you send a deposit to their emergency contact?
So let's presume that they're entitled to the deposit and therefore an itemized deduction list of any amounts you did lawfully deduct. And let's say that amount is $1,000 and you've got a check for $1,000. There's a couple of things that I recommend. Number one, if you do have some way to communicate with them, you can send them notice through email or text or fax or whatever saying, I've got a refund for you. Give me a forwarding address and I will mail it to you. That's one option. But if you have zero communication, none at all, the phone number is no longer in service and there are no options, you could potentially mail it to the rental unit. Because what they may have done, even if they didn't update you, and sometimes tenants hide from their prior landlords for whatever reason, and they don't want to give that information. But if you do have a refund to send, you could potentially mail it to the rental unit, because if they're having their mail forwarded to them, the U.S. Postal Service will forward that letter to their new address. And you'll know that happened because the check will get cashed and the envelope will never have been returned to you. So that's good evidence that you've done your part. You're not technically required to do it, but it's something that you could do if you do have a refund and you just want to say, look, I complied with my part of the agreement, even though the property code says until they give you that forwarding address, the 30-day time limit doesn't even start to tick. If you mailed it and it just goes to the unit and a new tenant comes in and says, hey, I got mail for this other guy, and you see it's the letter you sent with a refund, you can take it and say, all right, I'll take that. And now you've got the stamp from the U.S. Postal Service saying that you did deliver it in the event that it's ever an issue where you're being sued for wrongful withholding. Otherwise, hopefully it does get to them, but it may not. And again, you're not even technically required to do it until they give you a forwarding address. And from that date, you've got 30 additional days. Technically, they would have 4 years to collect it, because any breach of contract claim would last for 4 years. But, and the code is a little bit nebulous on what to do in this situation. It says you have no obligation until they give you that forwarding address. Well, let's say 3.5 years pass and they're like, I wonder if I was entitled to a refund, and they send you a forwarding address. Guess what? The code appears to say from that point on, you've got 30 days to get them the refund. If more than 4 years have passed, I don't see how they would have any claim to it. They've waived it by statute of limitations. They would have no claim for breach or no claim for you wrongfully withholding anything. But typically, if you're going to get it, you're going to get it within the first 90 days of them moving. That's typical. If you haven't gotten it by then, chances are very, very small that you'll ever get it. If you are interested in checking out what we do on my website is very easy. It's www.attorneyeg.com. That's me, attorneyeg, as in my initials, attorneyeg.com. You'll get to our website. You'll get links to all the kinds of services and things that we provide. We serve landlords and property managers and property investors all over the state of Texas. So wherever you are, we can be of service to you, and we're happy to do that. And for any of you who are on Facebook, and I hope all of you are, and have not checked out my Facebook group, you can go to Texas Landlords on Facebook. There we have over 6,800 landlords who daily participate in all sorts of Q&A and advice. They'll post problems and scenarios just like the ones we discussed here. My staff and I review this virtually 24 hours a day, asking and answering questions, giving as good advice as we can. But the greatest resource is the 6,800 landlords who are there sharing their input from all over the state of Texas about what they do when problems pop up in their area, whether it's you need a repair person, or you're dealing with insurance claims, or maybe you've got a tenant who has violated the lease for the millionth time. What do you do in this situation? We got people who are sharing their experience and their information nonstop on Texas Landlords. So whether it's checking me out online on my website, seeing what we do on YouTube, or visiting us on Facebook, we absolutely welcome you to join us in any one of those.